So moving backward again, 123. However, I do not accept that there is a high degree of probability that the defendant poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order. So this is the cancelling of the order. There is no acceptance that a high degree of gambling that the defendant poses an unacceptable risk. See, this is wherein we already realise coming into this order that the state took a gamble, and the probability of that gamble hasn't paid off. That they've made some serious errors in judgment along the way in their attack of something which at law needs to be defined. 122. It seems to me that the requirements of subsection 20A and B of the Act have been met. I entertain some doubt that section 20C has been met, but I consider it just made out on a revisionary and reconstructed analysis that because of some of the identified past activities of the defendant, with hindsight, he could be viewed as a, open quote, convicted New South Wales terrorism activity offender, close quote. And we can see how the police have used their knowledge of what they're doing in a bid to tar someone so they can feather them later. This is what they have done in the first incarceration due to a toy gun, and which they would try and attempt to slur the United Kingdom of Australia through actions of someone who had neighbourhood dispute. That is about the crux of where the police have come from here, in that they have used a neighbourhood dispute as their reasoning to label someone as a terrorist offender because they have a toy gun in their home. That is literally the statement being made here by the State of New South Wales on behalf of the Attorney General after what we've already discussed. Who is acting like a terrorist when they use a state protection squad to enact an attack before they have a need to protect themselves from their very own undoings? We can see this in the Barilaro Geordies case very clearly. We can see how the state have used State Protection Squad in a bid to silence what would be outing an action by the state through journalist activities or legal activities. And I prefer the latter. Am I satisfied to a high degree of probability that the offender poses an unacceptable risk of committing a serious terrorism offence if not kept under supervision under the order? I am not satisfied. I entertain some doubt. I consider it to be made on a revisionary and reconstructed analysis. In other words, you made all of this up in a bid to tar someone with your brush. 121. There is no doubt that in the past the defendant engaged in and professed beliefs of an ideological nature subscribed to by the United Kingdom of Australia. There is a lack of contemporaneous information as to whether he is in fact subscribes to these beliefs or not. It is at least possible that the ongoing treatment of his mental illness with medication has led to a recalibration of his delusions and previously fixed belief system. Imprisonment has also had a role. At the time of the assessment by Dr. White, June 2021, the defendant said he did not believe those things anymore. Dr. White reported no cynicism about that assertion, and there is no current evidence adduced by the plaintiff that demonstrates a contrary position. Okay, so there's no evidence added by the police to the position of Dr. White in that they have recalibrated his delusions that this country is somewhat under administration by foreign powers, given that the United Nations knocked on these people's doors in the last fortnight. The ideological nature subscribed to by ideological, the beliefs, we're going backwards now through the fact that to believe in God would be an ideology in these people's minds. To have any subscription outside of their very doctrine would be a belief of an ideological nature. (120) I agree with the submissions of the defendant that the defendant was not dealt with as a, open quote, terrorism, close quote, offender, nor were the charges levelled against him framed as terrorist offences under the Code. Section 25(3)(l), beliefs or commitments of the offender, whether of an ideological, religious, political, social or other nature that support engaging or participating in terrorism activities. So basically just being you, ideological, religious, political, social, having an opinion or other, just having an opinion could render you participating in terrorism activities according to the state. And then tarring you with that brush while going through offences of different nature because you had a challenge with the justice within that courtroom, were then surrounded by police and tarred with a brush. Let's get real here, because this is what they do. This is what they did. They won't answer the questions. They'll tar you with a brush and put you into a mental institution for having those beliefs. 119. There is, in my view, no relevant previous pattern of criminal offending. Section 25(3)(k), the views of the sentencing court at the time the sentence of imprisonment was imposed on the offender. So we don't know at this point which sentencing court. I assume it's the neighbourhood dispute, which would be no pattern of criminal offence because he's just having a bargee with the neighbour. So no relevant previous pattern leads to the question of why are these beliefs wrong? Why are these beliefs in any way wrong and what threat are they to the state if this is the action that the state's willing to go to stop someone having these beliefs?